So now I want to move forward and introduce Eleonore Zwinger. Uh, I hope I'm pronouncing it right. Okay. Is the Senior Staff Attorney and Director in Alameda County Immigration Programs at the Immigration Institute of the Bay Area. Eleonore was born and raised in Germany and studied law at the University of Passau in the state of Bavaria. Since 1995, she has practiced law in Germany and has worked there as an attorney until 1999. After arriving to the United States, she studied for the California State Bar, and in 2002, she was admitted to practice law in California. Since 2003, she has worked for Immigration Institute of the Bay Area, a nonprofit organization that provides high quality, low cost, or free immigration legal services, practicing exclusively immigration law. Her current job title, as I mentioned before, is Senior Staff Attorney and Alameda County Regional Director. And we appreciate you for being here. So welcome, Eleonore.
Thank you very much, Juliana, and it's also good to see you again and to be at the group again and present again. My colleague Sarah McPherson has been was doing the presentations before. She and her, we are alternating depending on our schedules. So she wasn't able to do it today. So I am happy to do it today and be with you guys. It's really good. Thank you. And I want to start with giving a presentation, a quick overview of what we are doing, and then dive into some updates under the Biden administration. There are some good things happening, and then give you an overview of different forms of immigration relief, and also a little bit about Know Your Rights in case there is immigration enforcement happening. Leah, if you want to, yes, perfect, thank you. So our organization, we have been around for over 100 years, and having helped immigrants in the very beginning, it was more about refugee resettlement, and now we are doing strictly immigration law. As you can see on the slide, we have several offices in the Bay Area. Our main office is in San Francisco, Oakland and Redwood City. These are the Alameda County offices. I am representing today those two offices. We have an office in Napa and in Sonoma, and also in the South Bay in Redwood City. And like I said, we do immigration law, family immigration law, also a little bit of asylum. We do a little bit of removal defense, mainly affirmative applications. We do Daca applications, deferred action for childhood arrivals, naturalizations, family reunification through consular processing or adjustment of status. And I will explain a little bit more what that all means. And also U Visas and Vawa petitions for victims of domestic violence and violent crimes, which is also very important. And I will go a little bit into detail about that as well. We are still working remotely, so we are around. We are rotating in our offices, but don't see clients at our offices because of, COVID is still around. But we are up and running and we make appointments with clients. We communicate with them over the phone, or if they are technically equipped, could be through Zoom or Google Hangouts, and fill out the forms for them, do consultations, and go back and forth with them for signatures. So we have managed to keep our practice fully running throughout the pandemic, and are able to serve the community. In our Oakland office, we have our intake clinic. It used to be a walk-in intake clinic every Thursday from 9 to 1 and from 9 to 12 and from 1 to 5. This is not a walk-in clinic right now, but we are scheduling half-hour appointments for people who need our legal advice, and do those on Thursdays. In our Fremont office, we do those on Mondays. And a lot of our services are free, but not everything is free. So if we have to charge, then we do that on a sliding fee scale according to household size and household income. For example, in our consultations in the Oakland and the Fremont office, when we do a consultation about U Visa Vawa for victims of domestic violence, those consultations are for free. If we do a Daca consultation, that's also for free. If we do a regular family-based consultation on a Thursday, for example, or a naturalization consultation, then we are charging $30 for that consultation. And then if we do the actual application, we always check whether we have funding so that we can do the application for free. That people don't have to pay for our service, but if it's not covered by a grant, then we will go back to our charging according to household size and household income. And that way we can help or can serve everybody. So we do not have to turn people away just because they might not live in a certain area or we might not have funding. And also people, if we have to charge, people can do this, can do their payments. Then often there are immigration fees as well. Those have to be covered by the client, but I just wanted to give a little bit of an overview. So if people would like to do a consultation with us, get an idea whether they qualify for an immigration benefit, I recommend that they call us. You see the telephone numbers for the different offices depending in what county people are living. For Oakland and Fremont, the numbers are up as well. Please call us, and then our receptionist will get back to you, I would say within about 2 business days, 2 to 3 business days. We get a lot of calls, so please be a little bit patient with us. We will return the call, but it may not be the same day or the next day, but we definitely return the calls. So that's just a little bit an overview of what we are doing and how we are operating, particularly still during the pandemic. And we hope that we will be gradually opening our offices, going forward, and we will keep you posted. Okay. Leah, if you could do the next slide, please. Okay. So that's kind of the outline of what I will be talking with you today. And I will go over the presentation, and then I'm super happy to try to answer questions if you have questions. And first, it's a little monologue from me, a little bit of a presentation. So I want to keep you updated what's new under Biden, then give you a little bit of an overview over common immigration remedies, know your rights in case there is immigration enforcement, and then the resources in the community. And I already talked a little bit about that as well. Okay. So what's new? So we are all happy that we have the Biden administration, and this definitely makes a difference for us. What I want to say is that in regards to legislation is still proposed. So there has not been new legislation. Those new legislation has to go through the House and the Senate. And that's not an easy thing. So there have been proposals, particularly the one in the second bullet point that the Biden administration proposed pretty much right after they started working on January, after the swearing in after January 2nd, January 20th, sorry. And this would provide a path to permanent residency for a majority of people who entered the United States before January 1st, 2021. So please be aware that this is a proposal. This is proposed legislation. That legislation and also the other one that is mentioned before would provide legislation, a path to permanent residency for people who are on Dacas and some people who are on TPS. And there is a third one also for essential workers. But the second one in the second bullet point, that would be the broadest. Those are not laws. They have to go through the Senate. They have to go through all the procedures, and then we see whether it gets passed or not. I recently had a consultation with somebody who said, well, there are all these people coming to the border and they are all getting work permits and green cards. The person wanted to know whether they can qualify as well, who is in the United States. And so that person was under the incorrect impression that these people are coming to the border because we have a new law and people can get lawful permanent resident status under an amnesty. And that is not the case. People are coming to the border, to the southern border, because they are fleeing, bad situations in their home countries, and they are, possibly fearing for their lives, and etc. So those are people who probably come to the border and see if they can apply for asylum. This is not because there is a new law out there that people could come to the United States and get a lawful permanent resident status. So I just wanted to make this clear in case there are questions that are presented to you. People think that they can come to the United States and can get papers. That is not the case. There is no new law. All the laws that we have are still in existence. There is nothing new. What were changes is where the Trump administration changed things for the worse during their administration. There were no law changes either, but they changed within executive actions, they maybe changed regulations or practices within existing laws, and the Biden administration tries to change that back to where it was before Trump, to make things more humane again. So I just wanted to mention that a little bit, in more detail, so that people don't think that there were any law changes or there was any amnesty. There is absolutely none. Okay. That is another law that another senator, introduced in regards to essential workers. We will have to see what comes about. It would be wonderful if we had immigration reform. As you heard in the introductions, I have been around in immigration law since 2003 with IIBA, and we have, throughout those many years now, we have had hopes. Legislation was introduced, and then those hopes were again crushed because nothing happened in terms of real legislation and immigration reform. So we hope and see, and it would be wonderful if this administration could do some immigration reform that helps a significant amount of immigrants and make things much better and much easier. So this law, this proposal is one for essential workers. We will see what happens within all these three proposals, what comes out of it. Something more tangible, what actually happened and where our actual changes is that if you remember that the Trump administration made the public charge rule much stricter, much harder to comply with, basically with the intent to let less people immigrate. So that public charge rule was reversed to where it was before the Trump administration. We have always had a public charge rule, but it was much more manageable and much easier. For example, it was that when people immigrate from outside the United States, that they had to now suddenly show that they have health insurance and things like that, and the immigrants' income and earnings potential was much more relevant. Now it goes back to when there is family-based immigration, that the petitioner needs to make 125% of the poverty line or more to be the sponsor to when the person petitions for somebody to become a lawful permanent resident. So whatever the immigrant makes is not relevant. That's one thing. Also, in regards to public benefits, means-tested public benefits, food stamps, cash aid, Medi-Cal, etc., that is also back to where it was before. In family-based immigration, public benefits that the immigrant receives may matter. This was always like that, but it is not as damaging as it was in the Trump administration. And for people who came here based on asylum, based on refugee status, who have U visa, Vawa, those are not subject to public charge. They are, and that was also under the Trump administration, where people are beneficiaries of humanitarian forms of relief. They were not subject to the public charge rule, and they still are not. So we are very relieved that the public charge went back to the way it was before, because it is much more humane and makes much more sense, and does not limit as much people who can immigrate to the United States. Also, what I wanted to mention is, speaking of immigrating, especially from outside the United States, the consulates are open and up and running again and are scheduling interviews again. There was also a stop under the Trump administration. He was kind of using the pandemic also to limit immigration, so that is gone as well. So consulates are open. I just saw today we got an interview scheduled at the U.S. consulate in Liberia, actually, for the husband and the child of a lawful permanent resident. So that is proof to me that they are working regularly again. There may be a backlog, it may take longer, but everything is running normally again. That is also a change to the Trump administration. And also the Muslim ban is gone. That was, I think, one of the very first things that President Biden did on his first day in office to reverse the ban for people from predominantly Muslim countries to get immigration benefits come to the United States. So that was a big thing as well, and was done immediately. Also, we have TPS. This is temporary protected status for citizens, a new temporary protective status for citizens of Venezuela or Syria. President Trump also, former President Trump, also, tried to get rid of temporary protected status, particularly for people from El Salvador and other Central American countries, people who had TPS for a long time. He ultimately didn't succeed because there were a lot of lawsuits going on, and so he couldn't do it in the end. But that is reversed as well. And I think some of the new law proposals want to look into or provide an avenue for possibly lawful permanent residency for people who are on TPS status. But also there is the new TPS status for people from Venezuela and Syria. A little bit later in the presentation, I will go into what TPS status means, so that it all makes a little bit more sense what I said. And then, of course, there is a big thing also that people can apply for DACA, again, Deferred Action for Childhood Arrivals. That was an executive action by former President Obama in 2012. It was highly, contested, and it had definitely its ups and downs, especially under the Trump administration. And until shortly before Biden came into office, we were only able to do DACA renewal applications, and also people who had DACA could not travel on advance parole anymore. But then right before President Biden came into office, through a court decision, DACA had to be opened again for initial DACA applications, and also obviously continuing with the DACA renewals, and also so that people could apply for permission to travel again. And then obviously the Biden administration fully implemented it again, and I believe also with executive action, so that DACA is fully up and running again the way it was instituted in 2012. Trump had then started to only give work permits for 1 year instead of the normal 2 years. That is also back to 2 years. So we are, like I said, we are up and running with DACA like it was in 2012, which is huge. So if you know people who qualify for initial DACA who have not applied for DACA because they couldn't and were not aware that it is now open again to apply, then please have them call us, and so we can schedule an appointment for a consultation to make sure that people qualify. And if people qualify, then we can do the DACA application. We are not charging for DACA initial applications, DACA renewals, because we have funding for that. People will have to pay the immigration fee, which is $495. Sometimes we have funding for that as well. We are currently working on that, but so far at the moment, people have to pay the filing fee, but our fee is waived. We are not charging for that. Also, there were some changes for the citizenship test, again, under the Trump administration, to make those tests harder. That was also reversed. We are back to the citizenship test, civics and history test, with the naturalizations the way it was before the Trump administration, simply making it more possible for people to apply for citizenship. So processing times are still long. They really got much longer under the former Trump administration. Processing times are still long. We at immigration, at the consulates, we hope that over time that gets better again as well. We do not know. I mean, the pandemic certainly didn't help with that either. But I believe that, immigration was not a top priority, or positive immigration was not a top priority under the Trump administration. So I think there were less people in general working, particularly in the consulates. So hopefully processing times will change again, but that takes time. And then this morning, we heard that the Biden administration increased the number for refugees who can come, are allowed in the United States again. Trump reduced it to, I think, 15,000 per year, which is, like nothing. And the Biden administration just upped it again to the 62,500. So that is a much better number. I think the Biden administration deals with a lot of, logistical issues, leftovers from the Trump administration in regards to managing the influx of people who come to the border, who apply for asylum. So I think it will take some time to fix that, over time, the whole process and everything. But I'm pretty sure that they are working on that. I cannot speak for the Biden administration, but that's what I hear also in the news. Our office, we do some removal defense. We do some applications for asylum, but we have very, very limited capacity to do that. We want to do our part, but due to funding, obviously those applications, we are not charging for them, but we have limitations on doing them. I just wanted to mention that. And again, those are our phone numbers. If people want to make appointments, it's really, really, really important. If people want to know or want to find out if they have, any form of immigration relief, if they think they can qualify for something, either if they are undocumented or if they are on a temporary visa, how they can change, their status. It's really important to get legal advice. We are attorneys and Department of Justice accredited representatives. We are not notarios. We are well trained. We have experience, and we give people honest legal advice about the possibilities they have. Or if we unfortunately find that they do not have an immigration relief at the moment, we tell them honestly as well and give them some advice what they should do and what they should not do. And if we have to charge, we charge. And if we can do services for free, we gladly do that as well. But it is, I think, really, really important to get reliable legal advice. And if we don't know something, or if it's not our area of expertise, we give valuable referrals. So we have a referral list. We know what other organizations or private attorneys in our communities do, and we give referrals. And there is just a quick reminder on the slide. If people are scheduled for immigration interviews at USCIS, they are doing those now. Please wear a mask. Please bring your own pen. That's obviously a pandemic thing. own blue or black pen, doesn't matter, and then have an interpreter available on the phone. Immigration, they have interpreters on the phone. So yeah, just a quick reminder if somebody has an interview coming up. Going back a little bit more to public charge, unemployment insurance is not a public benefit, has never been. But in order to get public unemployment insurance, this is somebody who has had, work authorization in order to be eligible. Actually, income people have based on unemployment insurance can actually be counted as income under an affidavit of support that needs to be filed. So it's clearly not a public benefit. Also, stimulus checks from the federal government or the state are definitely not public benefits. Treatment, vaccines, and tests for COVID-19 are absolutely not considered public benefits, and people really should use whatever they are being offered. So don't be shy, do your tests, your COVID tests, do your vaccinations or treatment, whatever is necessary. And, if you get stimulus checks, wonderful, use them. They are definitely, you don't have to worry about that at all. So I saw in the chat, sorry, there are phone calls coming in, let me just silence that. I saw some questions about Daca in the chat. So let's just go over the requirements for Daca, because I think it may answer some questions. And the Daca requirements, it's about a lot of dates, but you all, I think you have access to the PowerPoint to this presentation. So you will see what our telephone numbers, our addresses, and you see the requirements, but we can always schedule an appointment to definitely go into detail whether somebody qualifies or not. So under Daca, so you can see it's a lot of dates, and you will have, if you I believe that Beth and Leah and Juliana are sharing the presentation, so you have the requirements for Daca on the in your paperwork. It's a lot of dates, so you can double check. So deferred action for childhood arrivals. Somebody, in order to qualify for initial Daca, which is now available again, you have to be under the age of 31 as of June 15, 2012. Why June 15, 2012? Because that's when former President Obama announced Daca. Then you must have come to the United States before reaching the age of 16. And you must have continuously resided in the US since June 15, 2007. So somebody who arrived after June 15, 2007 for the first time, this person does not qualify for Daca. So people must have been in the United States from before June 15, 2007. And they must have been under the age of 16 when they arrived. Some people were really, really little. They are only now aging in to, Daca. But they must have been here from before, June 15, 2007. They also have to show that they were physically present in the US on June 15, 2012. And they must have entered without inspection before June 15, 2012, or had lawful immigration status that expired by June 15, 2012. So basically, they must have been without legal status on June 15, 2012. If somebody was on a visitor visa or on a work visa on June 15, 2012 and had legal status, even if they had been in the United States before that, if they were not in unlawful status on June 15, 2012, they would not qualify for DACA. They also need to meet the educational requirements. They must be in high school or must have finished high school. They may go to college, but the big thing is what we see most, that people finished high school or are currently in school. So that's a requirement. Or if people, let's say, dropped out of high school, if they go into a GED program or into some other, possibly vocational programs, that can work as well. So if somebody dropped out of high school, it might be a good thing to either, enroll in a high school degree program again or a GED program, so that they might be able to qualify for DACA. There is also the honorable discharge of the US Armed Forces or Coast Guard. I don't know, I have been doing DACA since 2012 off and on. I'm not sure whether I have seen it or whether other colleagues in my office have seen it. I think that's probably very rare, but what we definitely see is people in school or people dropped out of school and then start with school again. So that's definitely important. And then DACA is pretty strict when it comes into criminal issues. A person must not have been convicted of a felony, a significant misdemeanor, or 3 or more other misdemeanors, and do not otherwise pose a threat to national security or public safety. And that's why it's also important that we have a little conversation and check on the eligibility with somebody who wants to apply for DACA. Even with people who apply for renewal, we always check if anything has changed, if they got arrested, hopefully not, if there was any conviction, because in general with immigration, but also particularly with DACA, we have to watch out in regards to criminal convictions. For example, a DUI, if somebody gets convicted or was convicted for a DUI, that does disqualify from DACA. So if somebody got arrested for a DUI, hopefully they have either a public defender or a defense attorney who maybe can plead it down to possibly a wet reckless. We have had success with a wet reckless driving conviction. But then of course we need to show that the person otherwise is a good person and does not pose a threat to national security or public safety. So the bottom line is, the best is if people do not get into trouble with the law. But if there was something, then we need to know. Our consultations are completely confidential and people should tell us the truth, and then we see whether somebody qualifies. And same also with the other requirements to see if they qualify for DACA, if they apply for initial DACA. And for the renewals, we just check if anything has changed. And I just want to let you know, when we do a DACA consultation, we also always check whether somebody qualifies for a stronger form of immigration relief, because DACA is an executive order. It is all what it is a protection against deportation. and the person gets a 2-year work permit. Daca itself does not lead to another form of immigration relief. You cannot move after you had 2 years of Daca to another form of relief automatically. Some of those proposals in the law, they are, they would like to bring a path for people who are on Daca, but there is none. So we always check if people are on Daca or apply for Daca, if they qualify for something different, for something better. And that's also good, when we to check on that when we do a legal consultation. And that was the issue with Daca, since it was not a law. It had its ups and downs depending on what administration we had. It could relatively easily be blocked, or certain things could be blocked by lawsuits, because it's just not strongly anchored, because it is not a law. But now we are in the Biden administration. I don't think anything will be changed anytime soon. So Daca is pretty safe. And if people qualify, I recommend everybody, to apply, because the benefits: the person gets a 2-year work permit, gets a social security number, can apply for the regular driver license. It's not an ID. It's not the driver license for undocumented person. And people, even if they are in removal proceedings or have a outstanding removal order, they can apply for Daca and are protected against deportation. And all those years since 2012, I remember still very well when it was announced, people were afraid, we have to give our addresses. Other people might live with us who are also undocumented. Are we being put on a list so that then the government can deport us? So people, definitely rightfully had concerns to apply for Daca, and say, okay, now we were able to be under the radar, and we went to school and we were working, and now if we give our information, is the government going after us? And I have to say, now there is never 100% safety, of course, but I have not seen it in all these years, even under the Trump administration, by applying for Daca or renewing Daca, that immigration would have used it to go after people, or to go after people in the household. So I feel comfortable telling people that if they think they qualify for Daca, to schedule an appointment for a consultation, see if they qualify, and if they do, to apply either to renew their Daca or to file for initial Daca. Now, I would say, is the time to do it. And that is basically another summary of what I just mentioned. So first-time applications are open again. Yes, we have to prove that people qualify for all those, requirements. It's a lot of paperwork, and it's a lot of years now, since 2007. But I think it's worth it, and we definitely can help. And Daca gets renewed every 2 years. So yeah, and people should really apply for the renewal about 5 months before the Daca expires, and they can see the expiration on their work permits. Then I want to talk about citizenship, because citizenship is also, that's the ultimate goal. And once somebody is a citizen, a person cannot be deported from the United States, a lawful permanent resident, if they do something that, is against their status, they can still be deported. So citizenship is definitely important, and also a U.S. citizen can vote. And voting, as we have seen, is very powerful and very, very important in order to safeguard our democracy. So the benefits for citizenship, like I just said, is voting. Travel and live outside the United States. If somebody is a lawful permanent resident and lives outside the United States for longer periods of time, they may lose their lawful permanent resident status. If a U.S. citizen decides to live outside the United States, they can live outside the country forever, basically. They do not lose their citizen status. Also, U.S. citizens, they can petition for family members to immigrate to the United States faster generally. Lawful permanent residents can petition for some family members as well, but there is generally a waiting time. If a U.S. citizen files a petition for a spouse, for an unmarried child under the age of 21, or for a parent, there is no waiting time. It's just, the processing times of the applications, but there is no extra waiting time. So it's also beneficial to become a U.S. citizen, because you may be able to immigrate your family members quicker. For example, like I said, U.S. citizens, they can petition their parents, which is quick. Siblings is not a quick process, but they can petition their siblings. A lawful permanent resident can only petition for spouses and unmarried children under the age of 21 and over 21. U.S. citizens can also petition for siblings and married children, but there is a waiting time, and that can be quite significant, but at least they can petition for them. As a lawful permanent resident, you can't. Then U.S. citizenship is a protection for you and your children if they are also U.S. citizens, because you cannot be deported. You are a U.S. citizen, you cannot be deported. A lawful permanent resident or somebody who is on a temporary visa can be deported. Public benefits, no limitations to public benefits. If somebody is a lawful permanent resident, there is possibly limitations on receiving public benefits because the petitioner or a co-sponsor, they signed an affidavit of support, and there may be limitations, but as a U.S. citizen, you have access to the full array of public benefits. You can also apply and get government jobs, and people can have dual citizenship. The US allows dual citizenship. Some countries are a little bit restrictive with dual citizenship. A person may also check with the home country. If they become a U.S. citizen, they may, under certain circumstances, lose their original citizenship. But that is something to check with the original country. The U.S. Is not against dual citizenship. And in order to qualify for naturalization, a person needs to be 18 years or older, needs to have been a lawful permanent resident for 5 years. If somebody is married to a U.S. citizen and the U.S. citizen spouse has been a U.S. citizen for 3 years, then they can apply for U.S. citizenship after 3 years, so they don't have to wait as long. And then people who apply for naturalization, they must have been physically present in the US for 30 months for half of the time of the 5 years. And if they can apply for citizenship after 3 years, being a lawful permanent resident, then they have to be, have to have been physically present in the last 18 months. And immigration is very, very strict about the physical presence. Is an absolute requirement. If people do not have that physical presence requirement, and immigration is counting the days, and they have their own records as well, then they would deny the naturalization. So that's always something. Again, every time when people ask, oh, I would like to apply for Daca, or I would apply for naturalization, I want to petition for somebody, we always do a consultation to make sure that the person is eligible and it is safe to apply. So when somebody is interested in naturalization, we go through a bunch of questions to make sure that the person qualifies, and and it's safe to apply. Same thing with a person must not have abandoned residence. That has to do with longer absences from living in the United States. So we always check on that. The person must be a person of good moral character. So we check, for example, if there have been any criminal convictions during the 5-year period before somebody applies for citizenship, or even before. We have to check on criminal convictions, not just for the good moral character, but also if somebody is deportable. So we take that very seriously, because we do not want to apply for somebody or file a naturalization application, and then that application gets denied because a person is deportable, because this type of failed naturalization application can lead actually to removal proceedings, to deportation proceedings. So applying for naturalization is something very, very good, but the Immigration Service looks at the whole immigration history. So we have to make sure that it's all safe when somebody applies for naturalization. And for example, with criminal convictions, we have to be careful. Also, filing and paying taxes when people apply for naturalization. Filing and paying taxes, as long as they have been lawful permanent residents, is very, very important. If people did not work and did not have to file taxes, that's fine. But if they had to file taxes, they need to do that. And if they had to pay taxes, they need to do that as well. If people are behind, let's say, with paying taxes, then before applying for naturalization, people need to fix that. Either they just pay what is overdue, or they arrange for a payment plan and keep paying on that. Also, child support. If, let's say, a person is divorced or separated and they have to pay child support or spousal support, if they are behind with payments, then they need to fix that as well, because it would affect their good moral character, and the Immigration Service would not give them the naturalization, would not approve the naturalization application if they are behind with that. Then naturalization has the test, the English and history and civics test. And I mentioned it before, they went back to the previous test, which is much easier to manage. And there are some exemptions. So from the test, or actually from the language requirement, for example. So if somebody is 50 years old and has been a permanent resident for 20 years, they have to study the 100 questions for civic and history, but they can do it in their own language, and they don't have to do a writing and reading test in English. If somebody is 55 years old or older and has been a permanent resident for 15 years or longer, they still also have to study the 100 questions, but in their own language. And again, they don't have to do the English reading and writing test. If somebody is 65 years old and a permanent resident for 20 years or longer, they can do it, the testing also in their own language, in their original language, and they only have to study 20 questions. And those are generally simpler questions. They pick the simpler questions from the 100 questions. And then at immigration, they have to study the 100 questions in their own language if they qualify for those exemptions. But then at the interview, they are asked 10 questions. Same like when you had to do it in English, you study 100 questions, but you are asked 10 questions, and then you have to have 6 questions out of the 10 right. And if you're exempt from the language requirement, then, like I said, you don't have to do the reading and writing test. If you have to do everything in English, then if you pass, let's say, the 10 questions, you had 6 of them right, then the officer asks you also to read one sentence in English and to write one sentence in English. And those are not super complicated sentences. So we also always check if somebody qualifies for the language exemption. And then, and I think I saw something in the chat as well, if somebody is, for example, very elderly and has memory issues, there is an exception to doing the test at all. And that is the N648 disability waiver. That is one where immigration is very, very strict about it, because there has been also some fraud with those. So people have to go. This is usually for people who suffer from mental incapacities. The traditional ones are Alzheimer's, dementia, chronic depression, where the memory is so affected that this person cannot retain information and therefore cannot study English and history, or it may just be history. People might speak English, but they cannot study the history questions. So those are the traditional things like Alzheimer's, dementia. I had somebody who had schizophrenia, for example, and they took very heavy medication, and the medication affected them and they could not retain information. But that needs to be that N648 needs to be prepared by a licensed psychologist or by a psychiatrist or a general medical doctor. And it needs to be really thoroughly explained why this person cannot study English and or history, and what tests they did. And it's not like, okay, this person goes one time to the medical professional and then they do a quick mini mental and it's all good. Normally people have to go there several times and they have to, present documentation about serious questions. And then the psychologist or the psychiatrist ideally, certifies that and signs the N648, and then that gets submitted to immigration, and then immigration decides whether they accept that N648 or not. If they don't accept it, then people can go back to the mental health professional and see if it can be beefed up, if it can be improved, or people could decide whether, in case something is maybe more borderline, if they can do the test. With naturalization, people always have two interviews. If they fail the test in the first interview, they can do the test in a second interview. And if they don't pass in the second interview, they are not getting deported, nothing happens, they can apply, but then they have to start applying for naturalization again. So yes, there is the N648 waiver, and we have worked with them and we have had success. but often those N648 waivers are not accepted at the first shot. So it's really, really, really important that the mental health professional or the doctor does a really, really good and thorough job in preparing those. For naturalization, in regards to fees, we are doing naturalizations for free unless somebody is way over 250% of the poverty line and can afford, our services, and is doing well financially, then we charge as well. But the vast majority of our naturalization applications we do for free. And with immigration, there is a fee waiver possibility. With Daca, like I said before, Daca, there is no possibility for a fee waiver with immigration. With citizenship, there is. And for example, if people are receiving public benefits are not an obstacle to citizenship at all. If people are on public benefits, they can apply for citizenship, and then they definitely, if they have the proof that they are receiving public benefits now, and for example, it could be just Medi-Cal and nothing else, we submit the letter that from, for example, Alameda County Social Services, that they are receiving Medi-Cal, and then usually the fee waiver gets approved. If somebody does not qualify for a fee waiver, naturalization, the immigration fee right now, including the fingerprint fee, is $725. So it's not cheap. And by the way, the Trump administration had also proposed fee increases, and in some cases very steep fee increases, and those are off the table as well. So the fees that we have currently, there is nothing on the horizon that I have seen that they would increase the fees. And if people qualify for naturalization, they went through the process and they got their naturalization approved, they will go, they get an appointment by immigration to take their oath of allegiance, and that's when they are being issued their naturalization certificate. And right after that, they can apply for a US passport, and then they are US citizens with all the rights and privileges, including, voting, and also possibly applying for other family members to immigrate to the United States. And then I talked about family petitions. So sometimes I get the question also, or people think, my spouse came from a different country, and I am a US citizen. This person, he or she is a citizen right now, right? Just by being married to me. And that is not the case. So the process is somebody comes to the United States or is in the United States, and then could be on a temporary visa, could be undocumented, or could have come on a visa and then the visa expires and the person is out of status. So the next step is always to see if that person can become a lawful permanent resident. That's always the stage before. And then once a person was a lawful permanent resident or has been a lawful permanent resident for 5 years or 3 years, then they can apply for citizenship. So there is not somebody comes to us and becomes a citizen automatically. There are some exceptions with children of US citizens, acquisition and derivation of citizenship. There are some exceptions. I'm not going into detail with that. If that might apply, I think it would be great to do a consultation. I just go through the general process with family petitions. So in our consultation, if somebody says, oh, my child turned 21, is a US citizen, or I am married to a US citizen, or I'm a US citizen now, or I was born here, I want to bring my parents to the United States, or they are here, they came with visitor visas, then we always check, can they apply for lawful permanent resident status? And if people are outside the United States, then that is a different process than if they are here. And again, we are asking a lot of questions. We have to be very careful because we always have to check, do they qualify? And do they have anything that prevents them from immigrating? So a US citizen can petition for an immediate relative, and there is no wait list. And I had mentioned it before, immediate relatives are spouses, children who are unmarried and under the age of 21, and parents if the citizen is over the age of 21. Those are immediate relatives. Those petitions, they go pretty fast in immigration terms. Other relatives, if a US citizen petitions for a married or unmarried son, for a married son or daughter, that's a pretty relatively slow process. There is a wait list. If a US citizen petitions for an unmarried son or daughter over the age of 21, there is a wait list as well. And if a US citizen petitions for a sibling or siblings, there is a wait list as well, and it can be quite long, but at least they can petition. Because when you see a lawful permanent resident, they can petition for a spouse and children under the age of 21 unmarried, and sons and daughters over the age of 21 unmarried, and that's it. And there is always a waiting time. So for lawful permanent residents, there are no so-called immediate relatives where there is a waiting time. That's the difference. And that's why, it's a good thing if a person can to apply to become a US citizen. And like I said before, there are two ways how you can immigrate to the United States based on family petitions, and that can be from within the United States or from outside the United States. And the first step in each petition is always the so-called I-130 family visa petition. This is always the start. If you do an adjustment of status, very often we file the I-130 family visa petition and the adjustment of status application forms, I-485, and there are more forms to include. We file them together. And we always check if somebody who is in the United States qualifies for adjustment of status. And there we always have to check, did the person come with a visa? Do we have proof that they came with a visa? Or if somebody entered without inspection, do they qualify under an old law? We call it 245I. You may have heard about it. And do they qualify under those requirements? If that's not the case, then they may not qualify for adjustment of status within the United States. Then we have to see for consular processing, which is as if they were outside the United States. Or if somebody has a family member, let's say a son and daughter who is over 21, and they want to bring their US citizen and they want to bring their parents to live with them, and the parents live abroad, then we are straight in consular processing. We start with the family visa petition, and then the rest of the processing goes through the US Department of State, and those are the US consulates in the country where the immigrant lives. If somebody is in the United States and let's say entered without inspection, for example, but is married to a US citizen, cannot file for adjustment of status, then we look whether this person can apply for a so-called I-601A waiver. That was something that was started under the Obama administration, and Trump did not touch that one. So that's all still in effect. And that would be asking for a waiver of the unlawful presence while the person is still within the United States. And if that provisional waiver is approved and there are no other issues, then the person would travel abroad to his or her home country for the consular interview. If the consular officer does not detect anything else, then they will accept this I-601A waiver, and then they will issue the immigrant visa, and the person can come back to the United States without a long waiting time with the immigrant visa, and then get the green card here. That waiver part that I just mentioned, that has a certain risk coming with it. So that is also very, very important to do a good consultation beforehand to make sure that that's something safe to do. But that's basically the two parts with family petitions from within the United States and outside the United States, and we always check that in our consultations. There are, for family-based immigrations, there are no fee waivers with immigration. And the reason is the US citizen or lawful permanent resident, they have to file the affidavit of support. That's where traditionally the public charge situation comes in and has always been that way. And so the petitioner, or if they don't have the income, then they might have a co-sponsor. They have to show that they have enough money, enough income, so that when the immigrant comes to the United States or adjusts status here, does not get public benefits, does not become a public charge. And therefore they say, well, people need to have enough money to support the immigrants, so there is also no fee waivers available. Generally, fee waivers from immigration are available for applications in the humanitarian realm, and we get to those in a moment also, or for naturalizations, for example. With family applications, family immigration applications, the problems often are that there can be a long wait list if people are not immediate relatives. There can be, the wait time can be decades, unfortunately. So that's the downside. So bottom line, the whole thing with chain immigration that was, this big deal in the former Trump administration, it doesn't really exist because often people have to wait for a very long time to even be able to immigrate. And then, the family-based immigration is very strict also in regards to inadmissibilities, criminal issues, or people having been here undocumented. There are bars, 10-year bars, 3-year bars, possibly permanent bars. So we have to check on those. Immigration, the immigration law is not very generous with those. If people lied to immigration at some point, then they might be precluded from immigrating, or they may qualify for a waiver. So we have to be always careful when we look into immigration possibilities in general, but also particularly with family petitions, because there can be pitfalls. Now, I had in the very beginning, I had mentioned TPS. This is temporary protective status, has existed since the early 2000s for countries, for example, for El Salvador, Nicaragua, Honduras, later then Haiti, later Nepal and Sudan. And, Trump wanted to get rid of those, but he was not really successful through court decisions, and now there is a court injunction, so those are automatically extended until October 2021. And then usually when people have been on temporary protected status, then they have a certain period within they renew their temporary protected status. And temporary protected status is for people from certain countries where there is, mainly, I think it was for natural, disasters, could be hurricanes, could be earthquakes, could have been also some civil unrest that the US government said people who are here in the United States from those countries, they are temporarily protected. They do not have to return, and they give them a certain period of time, always during which they can be here in the United States. And they also get a work permit. It's a similar, DACA was modeled after TPS, basically. So it's not a work visa, it's not a visa, it's a protection against deportation, and people get a work permit, and it's for a certain period of time and can be renewed. People get a work permit, they have a social, and they also have their driver license. And in regards to travel, if they want to travel, they need to have a permission from the government first. So also for people who are under temporary protected status, they need to apply for so-called advanced parole. And then once they have this granted, they can travel, and there are no restrictions, but they have to come back within the time that was granted for advanced parole. If people want to travel under DACA and they apply for the advanced parole under DACA, there has to be a special reason. It's usually for humanitarian reasons. Usually it's elderly or sick family member that they want to visit. It could be also for educational purposes or for work-related purposes if they need to leave the country. Under DACA, if somebody wants to travel on advanced parole, it's generally not for a vacation. There needs to be a reason. Under TPS, they don't need to have a specific reason, but in both cases, they need to have the permission from immigration first if they want to travel. And under TPS, there have been now more, countries added where people can apply for TPS if they are here in the United States. That is South Sudan, Syria, Yemen, and Somalia, and more recently now Venezuela. And Venezuela and Burma, Myanmar have recently been granted TPS. So that's something to keep in mind as well. And we can do a consultation and see if somebody applies. If you know somebody, please send them our way, and we can see if they qualify. And then again, like with DACA also and with TPS, TPS itself does not have a road to lawful permanent resident and US citizenship, same like with DACA. But if people are under TPS or under DACA, and if they can qualify for an avenue to lawful permanent resident status through a different way, they can do that. And they can have two applications at the same time. They can apply for renewal for TPS or for DACA, and can also at the same time apply, let's say, if they qualify for adjustment of status based on a marriage to a US citizen, for example, if they qualify. We always have to check if they qualify. So it's not like somebody is on TPS, but they are married to a US citizen. and then they cannot switch status. That's not the case. People can switch status, and we always check on that one. It's very important. We always ask people. And what we sometimes do is, depending on the situation of the client, and that's where consultations are so important, it may be that we recommend somebody on TPS or on Daca, that they apply for advanced parole and travel, and then they come back with permission, they enter the United States with parole, so to speak, and then they may qualify for adjustment of status. But these are all individual cases, so we always determine that on an individual basis. But it is definitely worth analyzing options. And then there is something that was something positive that was done I think it happened under the Trump administration, that citizens of Liberia who entered the US before November 20th, 2014 are eligible to apply for green cards. So if you are somebody who might qualify for that, or if you know somebody who can qualify for that, please contact us. And the deadline to apply for that particular benefit is December 20th, 2021. And then now I want to talk about protections for victims of crimes. This is also a big part of our practice at IIBA in all our offices. You may have heard of Vawa self-petitions, of U Visas, and also T Visas. We mainly do Vawa and U Visa applications. T Visas is for victims of human trafficking, could be sex trafficking or labor trafficking. We do those on a very limited basis, but it's definitely, we can do that. But so if you have the feeling, if you have the sense that somebody may have been a victim of human trafficking, please also, we can do a consultation. It would be very helpful, and then see if either we can help with a T visa, or if we refer to another organization. And the Vawa and U Visas, those are forms of relief for victims of domestic violence or violent crimes. Vawa is for victims of domestic violence. It's a self-petition for somebody who was abused by a US citizen or lawful permanent resident spouse, child, or parent. And this person is eligible for lawful permanent resident status. And Vawa, U Visa, and T Visa are one of the few forms of relief that are available for people who are in the United States undocumented, came to the United States without documentation. And so we are checking a lot in our consultations if somebody who is undocumented could qualify, was a victim of domestic violence, was a victim of a violent crime, and see if they could qualify for VAWA or for U Visa. Now, VAWA is only available to people who are victims of domestic violence, and the abuser was a US citizen or lawful permanent resident, and it's limited to spouse, child, or parent. So in regards to inadmissibilities, VAWA is definitely more generous than regular immigration. So we check on that as well. And it is a very, very, very powerful tool. So if you know somebody who is a victim of domestic violence and could potentially qualify for that, we definitely should make an appointment for a consultation. U Visa is is newer. Vawa has existed since 1996, was renewed 2000 and keeps being renewed. U Visa is a newer form of relief, and we have a lot of U Visa applications. I could do a separate presentation just for U Visa and Vawa. I just want to give an overview. And so if you hear that somebody may qualify, please send them our way. U Visa is if somebody was a victim of domestic violence or a violent crime, and the crimes are listed in the Immigration and Naturalization Act, and they cooperated with the police or with law enforcement in general, and they suffered substantial abuse, suffered substantial harm, then they can apply for a U Visa. And in terms of domestic violence, if somebody was a victim of domestic violence, in that case, it does not matter whether the couple was married, whether the abuser had legal status, was a US citizen or resident, even if the abuser was undocumented as well. If they have never been married, they may qualify for the U Visa. But the U Visa hinges on cooperation with law enforcement, making a police report, making a report, and cooperating with law enforcement. If the cooperation is not there, if there was not a police report, or if the person says, no, I don't want to press charges, I don't want this person arrested, then it gets very difficult to apply for a U Visa. And then the U Visa, same like VAWA, leads ultimately to lawful permanent residency. So if people are, in VAWA, they may be able to apply for lawful permanent resident status through adjustment of status at the same time. For U Visa, it is a person gets the U Visa for 4 years after living here in the United States for 3 years under the U Visa. Then in the 4th year, they can apply for lawful permanent resident status. Actually, they should. And then once they are lawful permanent residents, later they can apply. After 5 years, they can apply for citizenship. So U Visa, VAWA, and with the T Visa, the same like with the U Visa, if they had their visa for 3 years, they apply for a lawful permanent residence, and then later citizenship if they qualify. So those 3 applications are very, very powerful tools, particularly for somebody who does not have legal status in the United States. They are one of the very few things that people who are undocumented qualify for. Daca is another part where you have to be undocumented, but U Visa and VAWA and T Visas, they are anchored in the law. Those are laws, and those are status that that then lead to lawful permanent resident status. TPS or DACA are only temporary and is a protection against deportation. So one always looks if they can go for better status. VAWA, U Visa, and T Visa definitely are very strong forms of relief and can have a straight line to become lawful permanent, to go to lawful permanent residency, and then later on citizenship. And that's why we recommend, if people have been a victim of a crime, then they should report it to the police. They should not be afraid of law enforcement. They are entitled to the same protection by the police, regardless of immigration status. They should definitely file a police report. And should cooperate with law enforcement. They should not refuse, cooperation. They should help them if they are, if the police or law enforcement prosecution requests them to cooperate, they should do that. And then also we often refer in Alameda County, we refer victims of domestic violence to the Alameda County Family Justice Center, and they have also different agencies there who help, for example, victims of domestic violence with therapy, housing, support, victim witness, also protection against the abusive person. So there is, there is wraparound services available for victims of domestic violence particularly, but also in general for victims of violent crimes through the DA's office and victim witness, etc. So we encourage people who have been victims of domestic violence and other violent crimes to report it to the police and cooperate with the police in general, but also because maybe there is a U visa or Vawa or T visa possibility at the end. Then other options, I will just go into that really briefly because those are, I want you to be aware of those. Cancellation of removal, asylum, and special immigrant juvenile status. Cancellation of removal, that I want to say a little bit more because I hear it also in consultations or also during presentations when people say, oh, I know somebody, or I have been in the United States for more than 10 years. I have a child who has, maybe a severe illness or some disability, and my child is a US citizen or lawful permanent resident. Can I apply for lawful status for the time, meaning the 10 years? And then the situation is that I get hesitant because this is not an affirmative application. Like I mentioned the other applications before, this refers to cancellation of removal, and this is only available to somebody who is actually in deportation proceedings. So if somebody is undetected by immigration, is not in legal status here, and has that situation, then this person would have to get into deportation proceedings beforehand in order to potentially get the benefit of this application in removal proceedings. And that's very, very risky business. And we are generally not doing that. There are some attorneys who are doing that, but there one has to be really careful who to go to because there are some shady attorneys out there, or maybe even some notarios. This is very, very, I have seen it work, but one has to be very, very, very careful. And this is without really good legal advice and and care. It's very risky business. If somebody happens to be already in removal proceedings and qualifies, that's a different story. Then a person is not being put actively in removal proceedings and exposed to that risk. That person is already in removal proceedings, and you might as well try anything possible, legally possible, to see if a person qualifies for a form of relief. And cancellation and removal is not easy to get. There is very strong limitations on the amount. Then the person has to show extreme and unusual hardship to that qualifying family member. I do not recommend to do that actively, to put somebody in removal proceedings in order to qualify for that. If somebody is already in removal proceedings, it's a form of relief that we always look for. There might be some private attorneys who do that. I don't know exactly who is doing that, but again, I'm not advocating for doing that at all. In general, if somebody is already in removal proceedings, attorneys who practice in removal proceedings who represent people in removal proceedings, cancellation is a tool in the attorney's toolkit that they always look at. So private attorneys who do removal defense, they are also aware of cancellation of removal. And they may be somebody who can check, so they are very familiar with cancellation of removal. They could maybe responsibly check if somebody is not in removal proceedings, if it makes sense to go that route. But again, people have to be very, very, very careful and take it very, very seriously to go that route if they are not in removal proceedings. Asylum, those are applications if people, fear to return to their home country and are already in the United States or are seeking admission as at a port of entry. And those are people, I would say, who we see at the southern border. There it would be always to check if they qualify for asylum, and they would have credible fear interviews, and some of the people may qualify. They are then possibly allowed into the United States, and they are generally put in removal proceedings if they are at the border, and then they go through court proceedings and they can possibly file for asylum. Or if somebody came here, for example, on a visitor visa or crossed the United States without permission, and they fear going back to their home country, they can also apply with the Immigration Service in an affirmative application for asylum. And they generally have to do it within 1 year of entering the United States, whether they are in removal proceedings or not. So there is this 1 year deadline. And like I said, they have to show fear of return to the home country on account of race, religion, nationality, political opinion, or membership in a particular social group. And again, as always in immigration, every case is different, and consultation with an attorney or accredited representative is the key. If somebody qualified for asylum, got asylum approved, when somebody has asylum status and has lived in asylum status for 1 year in the United States, then they can apply for lawful permanent residence. And then after they have had lawful permanent residence for 5 years, then they can apply for citizenship. So asylum is also can have a straight line from asylum through lawful permanent residence to US citizen. And then we have special immigrant juvenile status. This is a form of relief for unmarried children under the age of 21 who have been declared dependent on a juvenile court or have been placed in custody of an individual or entity appointed by the court. And they must show that reunification with one or both parents is not a possibility because of abuse, neglect, or abandonment. So that's a special, status also for, often, for example, for unaccompanied minors. There it can happen as well, but also for children who have been here in the United States. And then I want to give you a little bit an overview about Know Your Rights. I think that is important as well. We don't hear that much about immigration enforcement at the moment, but definitely also the Biden administration can deport people. So I want to give just a little bit Know Your Rights overview, because I think it never can hurt to know about that. So in case there is an immigration enforcement, and again, you get the slides, you will have that information there. Those are telephone numbers. If you hear about enforcement in the different counties, those are telephone. That's a 24/7 hotline that people can call. And then, so if immigration, if ICE is knocking on the door, or in general, if you encounter ICE on the street, you do not have to give them information about the country where you were born and how you entered the United States. So don't do that. Don't say anything. Whether you entered with a visa, not a visa, without permission, you just don't say anything, and you don't say where you're from. If ICE is knocking on the door, you do not open the door. ICE, they have to show a warrant signed by a judge, and they almost never have that warrant signed by a judge. Sometimes they have a paper that's an internal document where they within USCIS, where they suggest that there should be immigration enforcement, that they should raid a home, but that's not a warrant signed by a judge. So sometimes people ask, they don't give any information, they just ask, yes, just slide it under the door, for example. And then you see, hopefully somebody is there who can identify the document, and who, because it's usually in English, and then they can see, is this a warrant or not? But most of the time, it's not a warrant by the judge. So do not open the door. And then also, if you are encountered by ICE, let's say you get detained, or you see ICE in the street, let's say you are detained, then often ICE wants you to sign a document where you agree to leaving the United States without going through court procedures. And that would be a voluntary return or voluntary departure without going to court. So this is something that you should not sign at all. Sometimes ICE pressures people, or often they pressure people to sign those things. People should never be signed should never sign those things without checking with an attorney first, whether that might be a good way to do it. Or, if they have to, if they may have a form of relief, and they could do that in immigration court by signing this thing and being sent back to their country, they may lose that opportunity. So that's why it's really important never to sign any document before checking with an immigration attorney to make sure whether this makes sense or not. These are red cards that the ILRC gave. Normally, when I go to a presentation in person, or when people from our office go, we bring a stack of cards, or sometimes other organizations, they even have them already. Those are those cards that you can distribute. You can even print that and give it to people. What shows on the slide, cut it out, put it together. Those are things that people who are undocumented can take with them. So as a reminder that what they should do and what they should not do. So it's a good way of spreading the word about what people who are undocumented should or should not do if they encounter ICE. And then if people are afraid or are worried that there might be some ICE action, they can prepare documentation, addresses, can talk with family members, friends, neighbors, in case they have children. Who would take care of the children in case they get into ICE custody. So basically to do those kind of have an emergency plan to a certain extent, have documents in a safe place, birth certificates, marriage certificates, maybe the passport with the visa and things like that, that they have to have it in a list. And have it at a place where it is accessible. So that's what we recommend as well. And in regards to ICE, well, I mean, the laws are there that there can be ICE enforcement. There is, but what I have seen, I think the Biden administration recently, I think he's not confirmed yet, but he is a former law enforcement. I think he's the police chief of some county or city in Texas. But he sounded, I mean, again, I read it in the news, who seemed pretty reasonable, who did not want to go along with the enforcements that the Trump administration had in mind, and did so. Yes, there can be ICE enforcement, and we know, the Obama administration deported a lot of people. So I do not know whether the Biden administration would go a similar route. At the moment, it doesn't sound like it. And also, the person who possibly will be in charge of ICE does not seem to be like some renegade, law enforcement officer who wants to deport as many people as possible. So yeah, and I saw something in regards to the red cards. Yes, they are coming from ILRC and they can be ordered there. Like I said, usually I would bring them, an amount of them to presentations, but you can go on the ILRC website and can order them. So I believe that in regards to immigration enforcement, that it will be more humane again. My understanding is also that the previous enforcement memos that came out later in the Obama administration, where they really prioritized who should be subject to deportation and who not. For example, if people have U visas pending, that they should not be priorities. My understanding, enforcement priorities, my understanding is that they reverted back to those priorities when Biden came into office, and not the way it was under Trump, where basically everybody was a priority. And then also very, very important in general, please do not go to notarios. There are some shady attorneys as well, unfortunately, but the people who we have on our referral list, who we generally refer to as private attorneys, and also ourselves and other organizations who we know, those are all attorneys who take their job seriously. Notarios are not allowed to give legal advice and to practice law. Those might be people who help with filling out forms, but when it comes to legal advice, I have seen it, that they gave legal advice, that they wrong legal advice, that they filed things that they were not supposed to file, that people ended up in removal proceedings, or people left the country when they should not have. So please be very careful about notarios. Also, like it says here in the second bullet point, if something is too good to be true, it probably is. And that's very true. And also, if somebody wants to travel outside the country, like I mentioned with the waivers or with advanced parole for Dacas or for TPS or in general, if somebody wants to travel outside, please get legal advice first. Let's check that so that we can see if it's safe, if it's good for a person to travel, because there is a chance that people, if we're not careful, that the person cannot come back, or it may take a long time until they can come back. And that's, again, That is not completely true that all the immigration consults are for free. A lot of them are, but sometimes we charge in our clinic $30. And we do representation in deportation matters in a limited capacity. We do legal assistance for naturalization, U visa, family petitions, Daca, TPS, green card renewals, replacement, all kinds of affirmative application. We do naturalization as individual applications and also as workshops. And we also provide classes to study for the citizenship interview. And that is again our telephone number. And I made it on time with the presentation, but I did not answer many questions. So if people want to stick around, I'm happy to stick around and try to answer what I can.
Okay, so I have a few questions to get to. So one, just to clarify, we had a question that says, does a person qualify for DACA if she entered the USA in 2020? She's 15 years old.
Unfortunately not.
Okay.
Yeah.
And then we have another one that says, how can someone get help with an expired J1 visa?
The J1 visa is, so if somebody wants to check if they qualify for something different, like immigrating to the United States based on family petitions and so on, we should do a consultation. If somebody wants to renew a J visa or a J visa is a temporary visa. It could be, often I see it with au pairs. It could be for work, for study also. It's those temporary visas. If they want to see if they qualify for a different visa or want to renew a J visa, if possible, that would be more, we are not doing those, for example, or in general, I would say nonprofits are not doing those. We would send those people to attorneys who do employment-based immigration or those work visas, those temporary visas. But if somebody has an expired J visa, for example, we have had clients who came to us, they were au pairs, for example, and then their J had expired and they met somebody and they want to apply now for a permanent residency based on marriage, then we can do that consultation and can see if they qualify. But if they need to stay in the realm of non-immigrant visas or immigration through employment possibly, then we would refer them out to private attorneys who do that type of immigration. That's the other branch of immigration law, so to speak, more the corporate branch, I would say.
Okay, thank you. And then we have a question about public charge and Medi-Cal. So is it not public charge and does it not affect green card process?
So yes, so if somebody applies for the green card based on a humanitarian visa, for example, U visa, Vawa, asylum, refugee, public charge and Medi-Cal and food stamps and cash aid and all those things are never an issue and never were, even under the Trump administration. If somebody applies for citizenship and gets public benefits for Medi-Cal or whatever, is not an issue as well. There were those things during the Trump administration where they scared people, and there were things in the press. Not at all. If somebody applies for the green card based on a family petition, then if the petitioner, if the US citizen gets food stamps, cash aid, SSI, Medi-Cal, whatever, does not matter. If an immigrant gets public benefits, if it was emergency, for example, like emergency Medi-Cal, or somebody got WIC, not an issue. If somebody receives other benefits, an immigrant, we probably would tend to say maybe you should stop getting those, because public charge is an issue in family, in regular based immigration. But I would say most people who don't have legal status, they wouldn't get those benefits anyways. And if their children who are born here or are US citizens, if they get it, it doesn't matter either. So it's a little bit of more nuanced answer, but if an immigrant, gets petitioned by a U.S. citizen, let's say U.S. citizen spouse petitions for somebody who came with a visa overstayed, and they most likely that person wouldn't get Medi-Cal anyways. But if they got something, maybe food stamps or something, maybe that person should stop. But if the U.S. citizen gets it, it doesn't matter.
Okay.
Yeah.
So I have a question about DACA application. How soon can someone expect to secure an appointment for DACA assistance, the initial application? I've been told in the past none were available.
So an appointment with us, I would say we have for initial DACAs for the screening, we do them during our Thursday clinic. So we are generally about 2 weeks booked out. So if somebody calls today, when our receptionist calls back, she's out sick today, but when she calls back, she would probably schedule about 2 weeks out, I would say.
Okay, thank
Get
you.
an appointment to do the screening, and then to see, whenever the next caseworker is available. That could be also in a week or so, possibly, to do an initial DACA. Sometimes we do also workshops, and we do them remotely as well. So we could do it, same with naturalizations. We can do them on an individual basis or through workshops, and we let them know what is available, and then people can pick and choose.
Great. And we could probably share some of that information too in our follow-up email.
Absolutely.
So I have another question, and just so people know, we're a little over, but thank you for sticking around if you want these questions answered. And we have another question that says, can a citizen make the U visa process be faster or petition for the U visa recipient, in this case, the spouse?
So we have to check. It really, really depends on the circumstances. The U visa process is a lengthy process. It's a very good process, but it has become longer and longer because there are only always 10,000 U visas available per year. So the waiting time is very long. So people may want to check if they in the meantime got married to a US citizen, if they can speed it up. Potentially the answer is a yes, but with the U visa, we have to be very careful with inadmissibilities. The U visa is very, very generous with waiving inadmissibilities, much more generous than the family-based immigration. So we have to look into what were the inadmissibilities in the U visa application, and then to see whether it is advisable to switch over to family-based immigration. In many cases, it's not, but sometimes, it could be, but it really, really depends on the case.
Thank you. And somebody wants to know if there's an example or what a legitimate warrant signed by a judge looks like, and do you have any tips on how to identify whether it's a legitimate document or something, or an ICE warrant?
I believe that there is possibly, maybe on the ILRC website, I'm not sure. There might be, under Know Your Rights, there might be some examples there, how a warrant looks like. I mean, you basically have to look at the signature page, at the signature, if that says, judge, if the word judge, because it has to be signed by a judge. If I think when we had a training once, they showed a document that was from internally from immigration, where it says something USCIS and something like that, then it's clearly not a warrant by a judge, because, and it will never be a warrant by an immigration judge. So I think the best thing would be to see who signed this thing and what says it underneath. It needs to be a district court judge or somebody like that. So yeah.
Great. And we can attach a sample too to our follow-up email. So we'll make sure
I could maybe see if I could say maybe ILRC or clinic, they may have something.
okay, we'll find one. And another question, can a U visa recipient request permission to travel, such as visiting parents?
Okay, so technically, somebody who has a U visa and is on U visa can apply. The thing is, they have to apply then for the actual visa, because while they are, if they got the U visa in the United States, they got U visa U status. So the moment they leave, they have to then go through the consular process to actually get the U visa in order to enter the United States. And then we are talking about the inadmissibilities again. There might be some bars and some things that they have to get waived. And at the same time, they have to also come back within a short period of time. Otherwise, they lose potentially the possibility to go from the U visa to the green card. So technically, they could travel, but we really advise against it. Because there are so many things that might need to be considered depending on the case. And then since immigration is so slow with waivers, with appointments and everything, they may not be able to come back within the time or may not have everything ready. There are so many moving parts that we advise against traveling while in U visa status, that we advise people to travel once they are lawful permanent resident, or maybe revisit if they apply for lawful permanent residence and then maybe ask for advanced parole. That might be easier. But in any case, if somebody thinks they want or need to travel, get the legal advice first. Don't book a flight or get in the car and just travel, because like I said, it can have really, really serious consequences. We can check and we give you an honest answer, even if it might not be the answer that the person wants to hear, or maybe there is a possibility to do it, but we have very, very, very few people who travel while on your visa.
Great, thank you. That was our main last question. Just to follow up, we'll add the red cards ordering link to the follow-up email, and we'll also add some links for public charge information to share some resources. And then I just want to thank you so much, Eleonore, for your time and this great update with so much new information and hope for our families, undocumented families looking for an immigration pathway. So I appreciate you. Thank you so much. And all our attendees who participated and are collecting all this information to share as well. Just want to let you all know the evaluation is going to go out. A link will go out in your email. It might be in your junk mail. So try to find it and it'll go out this afternoon. And we'll be sending the presentation and International Institute Bay Area contact info and all the phone numbers. So if there's any additional questions, feel free to call one of the sites to get support. So thank you all.
Thank you very, very much for listening, for absorbing. I know it's a lot of information, and in person is always different than virtually. But I enjoyed sharing the information. Thanks for your patience, and I really, really appreciate your interest. staying with me with my monologue. Thank you very much.
Thank you so much.